Play a quick video.
I'm sorry, did you ask me a question?
I recognize myself. We're going to play a quick video. Do you support reclassifying independent contractors as employees against their will?
For those workers that work in the gig economy, absolutely.
That was with the chosen witness of the minority at a recent hearing, so Dr. Katie Wells of Georgetown. Do you agree with her? Do you support classifying independent contractors as employees against their will?
I'm so sorry, Congressman. I didn't realize. Can you just do that again?
Sure. Let's play it again. Do you support reclassifying independent contractors as employees against their will?
For those workers that work in the gig economy, absolutely.
Agree? Disagree?
Well, Congressman, let me say, I do not agree that the acting Secretary of Labor has the authority to force any kind of classification against people's will. I will say that the laws of this country protect working people when they should be called employees and are misclassified as independent contractors.
So when you say, okay, when you say that you don't have the authority to do that against people's will, what do you mean? There's a new rule that you're going to go around enforcing that's going to change people's status, right?
I mean, I'm sorry, I watched that very quickly. It sounded like your question was, do you support forcibly making people who are independent contractors in the gig economy into employees?
Sure, and yes or no, do you support that?
Well, what I'm saying is nothing that we are doing at the Department of Labor, including putting out a rule that restores the employee versus independent contractor rule to decades of case law, again, not criteria that I made up, not a test that I thought should be put in place that I wrote. It's based on decades of case law interpreting the Fair Labor Standards Act.
And so nothing would do that, nothing about that would force someone into employee status against their will, correct? That's what you're saying.
I don't, that's a different question from the first question that you asked, though. So
not really. So if someone says, I want to be an independent contractor, that's good enough for you. You're not going to try to challenge that.
Well, the law says, again, this is not just about what I think, the law says that what you call someone, even if, let's say, they've signed an agreement saying, like, let's say that's what you would use, right? They signed an agreement saying they're an independent contractor.
Right.
They signed an agreement saying they would get 1099s, that should be enough. The case law is clear that that is not sufficient to find that someone is an independent contractor.
Okay, but you've just created a new rule that you are heavily involved in creating that received a lot of notice and comment, and you finalized it, you signed off on it. And so the question is whether under that rule, someone will be forcibly reclassified against their will. So let's take a concrete example. There's a group called Women in Motion. This is a group of truck drivers. Don't know if you've met with them. I'd really encourage you to. They're a great group, and they've told some stories. For example, we have Bambi. Is that Bambi behind me? Yes, it is. Who says that she likes to be an independent contractor. She's chosen to do so because I wanted to run my own business. I felt it was time for me to grow. And when asked how a ban on independent contracting would impact her life, she said it would be devastating. My family depends on my income and the flexibility that being an independent contractor provides. A ban or restriction would limit both of those. So can you assure Bambi, who is an owner-operator, a truck driver, that this new rule will not change her status?
Well, Congressman, the outcome of applying the test really does depend on the facts of a particular circumstance.
Okay, but she's an independent owner-operator, a truck driver. There's a lot of do you know how many of those people there are, by the way, in the country? Independent contractors or truck drivers?
Well, I understand that. I understand what you're saying. How
many are there? Do you know?
I don't know the answer to that.
Okay, there's about 350,000, I believe. So just take your standard, typical example. Bambi, can you assure her that you're not going to come after her and tell her that she's got to run her business differently now? Can you assure her of that?
So, Congressman, the purpose of having a rule and a test is so that we can make sure that working people who should be entitled to the protections of the Fair Labor Standards Act get them. That is not inconsistent with the ability of bona fide independent contractors to operate.
Okay, I'm
for
asking you a
profit.
simple question about this particular person. And you can answer these questions because when you were labor secretary, you didn't enforce AB 5 against whole categories of people that were exempted and were defined in the statute as it not being subject to. So I'm asking you right now, are independent owner-operator truck drivers going to be treated differently under the rule that you just published than they were under the pre-existing rule? Yes or no?
Well, first, let me say, Congressman, what you just said yourself is that several categories were exempted from AB 5. So therefore, not enforcing against them is what the law said, right? They were not covered by AB 5.
Right.
The point you're making and saying it's simple, I'm telling you it's not simple because you have to apply the facts of a case to the law.
You're missing the point. At the point at which in a statute you could say this whole category, this whole profession is exempt from the law, that was not a fact-dependent determination. And so I'm asking this particular profession, truck drivers, independent owner-operators, hundreds of thousands of them that are vital to our supply chain, can you give us an answer right now as to how they will be treated under this new rule?
Well, our new rule does not have entire exemptions for entire industries. That's not what the case law says. And so we were following both the plain language of the Fair Labor Standards Act and the cases that have interpreted it. That is what is within my authority to do, and that is what the final rule does.
Ms.